Welcome to Public Enemy Number 1, the police whistleblower. It's been 3 weeks since the launch of my podcast, and I'm now up to episode 5. If you haven't yet done so, please rate and share my podcast to increase viewership. And if you're looking for any supporting material, please don't forget to visit my website at policeversuswhistleblower.ca. That's policevswhistleblower.ca. Before we dive right into episode 5, I'd like to remind everyone how we got here. In 2016, I was just your average police constable working as a use of force instructor with nothing but positive documentations in my personnel file. I chose to speak up about something that I thought was wrong. And that's the only reason I'm not a police constable today. Here is what started it all.
The issue that I discovered is that, when you look at the OIPRD and the OCPC and even Police Services Board, there's all these mechanisms in place for civilians to bring a concern forward and for there to be oversight. But I was concerned with the lack of ability of members of police services to come forward. And I located a transcript online from 2007 when the OIPRD was being created. And there were individuals that pointed out that why would we prohibit a member from coming forward with a concern about their own service? Because again, they would be the best source of information. And at that time, I believe it was Graham Boswell, who at the time was working for the ministry, said it would be up to the service to have their own internal policies in place. But there's nothing requiring police services to obtain or continue to have a policy that permits members to complain. So we have to have legislative framework that is forcing police services to do certain things to allow oversight to happen from within. Because if you don't, you're allowing corrupt practices to continue. And there are some police officers that are willing to be the whistleblower and not be afraid, but without that legislative framework, you leave it up to the police services, and everybody wants to trust the police services, and we don't want confidence to be breached, but we have to make sure that there are mechanisms in place, because sometimes what is seen inside is worse than what the public is dealing with.
What you just heard was audio from a public session held in the fall of 2016 of the Independent Police Oversight Review conducted by Justice Michael Tulloch, who is now the Chief Justice of Ontario. This was the first time that I had shared my thoughts about internal police misconduct with anyone outside of my police service. Justice Tulloch took an interest in what I had to say, and as a result, he recommended whistleblower protection for police officers in his final report. As a result of his report, the Police Services Act underwent a review in 2018, and I was invited to speak at the Ontario Legislature. With only 5 minutes of airtime, I had to speak very quickly.
My name is Kelly Donovan, and up until June 2017, I was a police officer with Waterloo Regional Police. I represent thousands of police officers from across Ontario and Canada. I do not support Bill 175 as it stands now. During my time at Waterloo, I witnessed misfeasance during internal investigations of other police officers at the service, more specifically unlawful arrests of members, corrupt investigations, and criminal allegations being overlooked. Waterloo only allows members of the public to make a complaint of misconduct, and the OIPRD does not accept complaints from police officers. So therefore, I made a lawful delegation to my Police Services Board to disclose the misconduct of several high-ranking members of the service, and as a result, I was disciplined and silenced. Chief Brian Larkin ordered me to have no further contact with members of the board. I was relegated to administrative duties, and I was put under investigation for 8 Police Service Act charges. There was never a complaint from a member of the public. This was the result of a chief's complaint. Over the next 14 months, I was constructively dismissed. Chief Larkin used the Police Services Act to silence me so that I could no longer disclose to the board the unethical conduct happening within the service. Following my delegation to the board, another police service was contracted to conduct an impartial review of a recent internal criminal investigation. That review was negligent and biased and is refutable evidence that when police investigate police, there is bias. During my constructive dismissal, I wrote a 93-page report citing cases that show just how systemic misfeasance is in Ontario Police Services. and how often police chiefs and ineffective oversight bodies are able to silence police whistleblowers. This report is contained in tab A of my submission. I made complaints to all of the applicable police oversight bodies, and none of them chose to enforce their legislated authorities. In June 2017, a $167 million class action lawsuit was filed against Waterloo, and I believed that politicians would now start to listen to us police officers trying to expose to you what goes on behind closed doors. 2 weeks later, Chief Larkin was elected as president of the OACP, and it became very obvious to me that police chiefs in Ontario are above reproach as a result of our current and proposed legislation. When I resigned, I sent my report to 200 politicians in Ontario. Those emails are listed in tab B of my submission, and I believe 5 members of this community were on that list, or this committee, I apologize. I received a cookie-cutter response from Minister Lalonde, and I'd never received a response from Minister Nakvi at all. Despite Justice Tulloch recommending a whistleblower program for police officers, as a result of submissions like mine, this did not make it into the bill. In fact, I don't believe my report had any influence over Bill 175 in any way. I have 3 suggested amendments to the bill. Number 1, I would recommend that the bill be amended to combine Schedules 2, 3, and 4 into one special investigations unit. It is inefficient and costly to the taxpayer to have 3 separate oversight bodies, the Discipline Tribunal, Inspector General, and the SIU, all while still permitting chiefs to conduct their own investigations. This does not allow for more accountability and transparency. Each of these bodies determine if there are grounds for a criminal or provincial offence, including misconduct. The only differences between these bodies is who they investigate and from whom they receive their complaints. These investigators will be the most skilled, knowledgeable, objective, and ethical people. So why would we not maintain one central agency with satellite offices where resources can be shared? By changing the definition of official to include all persons in policing, the SIU would therefore investigate all complaints of criminality or misconduct, including the chief. Number 2, alternatively, I would like to see changes made to Part 6 of Schedule 1. Chiefs should not be exempt from disclosure requirements because they are not above the law. Inspectors should not be current officers, and it is blatantly obvious that a conflict of interest exists when you allow chiefs to investigate each other for criminal offences. With regard to Part 9 of Schedule 1, police officers should always be afforded the right to an impartial investigation. This is not achieved by allowing chiefs' complaints. Under the bill, officers lose their right to a fair trial, which violates their constitutional rights. Only after a sanction is imposed can the officer appeal the decision. All allegations of misconduct should be handled by one central agency for consistency and fairness. This would end internal systemic misfeasance. I have 500 signatures on a petition to support that recommendation. The lack of consultation prior to the release of Bill 175 shows a continued reluctance by government to accept the gravity of internal corruption that exists within our police services. I am living proof that internal corrupt practices are eliminating good, honest people from the profession. I was an exemplary police officer until Chief Larkin used internal discipline to constructively dismiss me. Nothing in Bill 175 would prevent what happened to me from happening again to another honest police officer. In fact, after I was diagnosed with post-traumatic stress disorder last February, I could have faced termination under Part 7 of Schedule 1. This bill was prepared in haste without adequate consultation with the right people. If police officers were not scared into keeping quiet, you would receive hundreds of submissions just like mine, and I appreciate the opportunity to address you today.
I wanted to share that with you because that was back in 2018, and I do believe that as a result of my delegation to the committee, there were positive changes made to the Police Services Act. Every police officer in Ontario is going to benefit from those changes to the laws. But it might surprise you to know that I have not had any support from my police association or the Police Association of Ontario. One of the first calls I made after I faced reprisal was to the president of the Police Association of Ontario. I truly believed that he would use my example as a platform for other police officers to speak up about what they see internally. I had had so many police officers say to me in private, "You hit the nail right on the head. Everything you said was so true, and things have to change." But no one was willing to be courageous enough to speak out publicly. But these police associations have the power to do so, with immunity. But what is well known in the policing community is that when there is a blue-on-blue complaint, and you can imagine what that means, somebody within the police service complaining about another member, the police association simply won't get involved. I mean, they are in a tricky spot. They're supposed to be representing the interests of all of their members. So when a complaint gets filed against another one of their members, who is it that they're supposed to support? Well, the problem has become, for several years, that because policing is primarily male dominated, I mean, Waterloo Regional Police is at least 80% sworn male membership, the association will tend to support the male member. That has just meant that for years and years, and in some cases decades, the female members reporting male members for sexual harassment have not had the support of their union. As I mentioned, at Waterloo Regional Police, the Waterloo Regional Police Association was named in the $167 million class action lawsuit. Some of the representative plaintiffs cited specific examples of times where they went to their representative from the association to tell them about the sexual harassment they were facing. Most of the time, the representative just said, "You're better off to not file a complaint because it'll ruin your career." It really didn't seem like addressing sexual harassment was a priority at the Waterloo Regional Police Association. But the story wasn't any different anywhere else. There has been very little progress made in policing in Canada to increase female membership. I'll share with you a little story. During the time that I was relegated to administrative duties, Chief Brian Larkin gave me permission to attend a Women in Leadership conference that the police service was hosting. The keynote speakers were Jennifer Evans and Kimberly Greenwood, two female police chiefs from police services in Ontario. As I always do, I found an opportunity to grab the mic and ask a question. And what I asked these two female police chiefs was, why do we continue to see it as progress when we can obtain more than 20% female membership within our police services? We seem to celebrate when we reach these milestones of 23 or 25% females, but I reminded them that our population is 50% roughly female. So why are we celebrating successes at 25% when we're still 25% deficient from representing the population? It's written right in the Police Services Act that the police service is mandated to represent the population. So when you look at diverse communities and you look at their police service, there is not one police service in Canada that can truly say they represent their population, mainly because they don't have the 50% female membership. But police services also struggle to attract and retain diverse members. I'm not going to get into the colonial past of policing in this country, but I do recommend that you listen to Dr. Pam Palmater's recent podcast about RCMP's colonial past. You will learn a lot about the history of policing in this country. And anyone who believes that there is no sexism or racism in policing is simply ignoring the facts. But the reason I'm telling you all of this is to point out the fact that from the very beginning, I've advocated for nothing but positive changes to policing in this country, and yet have not had the support of these police associations. And why is that? Well, what I've come to learn is that most police officers want to just keep their head down and fly under the radar, as they say, until retirement. Until they find themselves the subject of a corrupt investigation, it's not something that concerns them. But the problem with that is, what else is happening around these police officers that they're willing to turn a blind eye to simply to see their career reach its destination of retirement? You don't have to look very far to find scandal after scandal after scandal in police services across Canada. Police officers have historically been given a very high level of trust and autonomy to do their jobs, and we simply rely on the integrity level of each individual cop. Now that we have body cams and cell phone cameras, the public are learning that the lack of oversight has led to some police officers believing they are above the law. I know there are police officers out there today who still do not support my efforts, but I truly hope that they take a good long look at themselves in the mirror and try to remember why they got into this profession in the first place. I don't think problems in police leadership will ever change unless people stand together. But I didn't create this podcast for other police officers. I created this for members of the public. An informed population is a very scary thing for a police chief who's used to operating in a bubble. But I believe that transparency and accountability will help restore honor to the profession of policing. So, where I left off in episode 4 was about September of 2022. We were preparing for a preliminary hearing into only the 4 matters identified by the previous adjudicator, and we were requested to make new submissions ahead of that preliminary hearing. Well, to my surprise, the police service made a submission that pretty much said they consented to everything. They were now consenting to the amendment of my claim to include my second allegation, and they didn't have any issue with the fact that my initial application was filed outside of the 6-month period. It seemed like the police service was finally on board with us just proceeding to have these cases heard. After 4.5 years, we were finally having a hearing into the HRTO matters. And as I had done several times before, I also reiterated the fact that I had made requests to dismiss the police service's case, and those requests were not being heard. But I also addressed all of the current issues in my arguments. In the end, the tribunal adjudicator ruled that my second allegation of contravention of settlement, the WSIB appeal, would be allowed. The strange part about her ruling was, although she had accepted that my second allegation would be permitted, the adjudicator denied me pursuing my first allegation, claiming that it was filed too late. The adjudicator's justification for this was because she ruled that my 2 alleged breaches were very different in nature, and because they weren't the same, they did not constitute a series of contraventions. As I had expected, the tribunal dismissed my allegations of negligence and misfeasance in public office. I knew they had no jurisdiction over those claims. So the ultimate outcome of this decision was that my claim was reduced down to 1 contravention of settlement. It was determined that I had not committed an abuse of process by recording the teleconference call, and the police service had alluded to the fact that they would be amending their claim against me. So my attempt to hold them accountable in 2018 resulted in this protracted litigation that resulted in me proceeding with 1 measly allegation while the police service continued to mount a case against me. If you're not familiar with the term DARVO, I feel that that's exactly what the police service was doing in this case. DARVO is an acronym that stands for Deny, Attack, and Reverse Victim and Offender. And that's exactly what the police service had done in this case. From the time I filed my lawsuit against them on May 9th of 2018, they had denied, they had attacked me and reversed victim and offender. And here we were with their 500-page case against me, while I was only able to proceed with 1 allegation against them. I wasn't satisfied with this decision by the tribunal, and I filed for a reconsideration. It's actually a quite foolish procedure, but you're only allowed to ask the adjudicator themselves to reconsider their own decision to see if they'd made any errors. I wasn't expecting that anything positive would come from my request for reconsideration. So I also filed for judicial review. Judicial review is the only way to appeal a tribunal decision. It's sent to divisional court, typically in front of a panel of up to 3 judges, and the cost awards can be completely crippling. That's probably why more people don't pursue judicial review, but it's the only way to have a tribunal decision overturned. And as has been the theme for these past few episodes, I didn't feel I had any choice. The Court of Appeal had told me that if I wanted to access justice and if I wanted to try to hold the police service accountable, I had to exhaust all remedies. So if I had just stopped at this tribunal decision, was I really exhausting all remedies? My fear was that if I returned back to the Superior Court to have the stay lifted, I would be told that I didn't take my case as far as I could have. Had I gone to judicial review, perhaps the decision would have been made that I could have proceeded with both allegations. So, although there were no cost awards at the tribunal level, I knew that losing at judicial review would mean another significant cost award. But as I just mentioned, I really didn't feel like I had any choice. By this point, the legal writing had become much simpler since I had gained experience at the Court of Appeal. But as I had had to do for the previous 6 years of my life, all of the time I took to put into this legal research and writing was time taken away from my family and operating my business. This was becoming the new way of life, and I didn't like it. But as I know some of my critics will say, well, why didn't you just give up? And that was becoming the theme of my life. It was as if Kelly Donovan no longer had any rights at all. She clearly didn't have any protections in her resignation agreement. It was as if I had become the bad guy because I had chosen to speak up in 2016. They were successfully scaring any future police whistleblower into not ever speaking up about anything they witness inside their police service. I have believed all along that this was the end game. I just never imagined that so many different people would be participating in their efforts. So all of this was happening right before Christmas of 2022, and I was trying to focus on just making Christmas special for the family. When on December 23rd, late afternoon, right before the Christmas break, I received an email with the police service's amendment to their case. I didn't know what it was that they were going to amend, but I honestly thought that maybe they had some corrections to make. I had no idea that what they had planned was to submit evidence of what they believed were ongoing breaches of my resignation agreement from 2018 all the way up until December of 2022. The evidence contained in their amendment was clear that I had been under surveillance from 2018 until 2022. Everything I had done was contained in this amendment as a new allegation that I had allegedly breached my resignation agreement. Now, the details here are important. Someone either at the law firm or within the police service had sat through hours and hours of podcasts I had participated in. And I'm not kidding. Some of these podcast episodes were an hour to 2 hours. And someone sat and listened to the entire thing so they could pull any little soundbite out and accuse me of breaching my resignation agreement. They were even including transcripts of my presentations before the Ontario Legislature and the Manitoba Legislative Assembly, despite the fact that those would be covered under parliamentary privilege. So their 31-page complaint became a 38-page complaint, and there were about 200 additional pages of evidence attached. I may have already believed that their case against me was an attack on my fundamental freedoms and an attempt to cause me harm, but with this latest amendment, now I knew they were out for blood. I really believed at this moment that they weren't going to stop until I was 6 feet underground. I don't think I have to explain why Christmas 2022 was an extremely difficult time for me. This would be an appropriate moment for me to just take a minute, a bit of a moment of silence, to remember the women that came before me who had moments just like this and did not survive. It's for those women that I keep fighting today. But now you know how I became public enemy number 1 for the Waterloo Regional Police Service by simply speaking up when others stayed quiet. And at the end of December of 2022, the grand total had reached approximately $610,000 that the police service had spent of public funds in my matters alone. When we meet again in episode 6, I'm going to tell you about a key piece of evidence that I located in January of 2023, and it gave me enough energy to come out swinging. You won't want to miss episode 6, so please stay with me. Thanks for listening.